Hello, we are just opening up the room for attendees. So, as you are joining, you should be able to see the cover slide for today's presentation, Remote Employees in New York. If you can see that and hear me, then you should be in good shape. We'll just wait for everyone else to sign in. Welcome, everyone, as you're joining. We will get started in just a few minutes. Thanks for attending today's webinar. As you're getting signed in, hopefully you can see the cover slide for today's presentation. There is also a chat window where you will be able to enter any questions you have so that I can answer those. We will generally answer the questions in a question and answer segment at the end of the presentation, but if I see your question and I can work the answer into the presentation as we go, we will do that as well. I always encourage you to type in your questions whenever you have them so that you do not forget. We will get started in just a couple of minutes. As you're joining, I am Scott Horton. I will be the presenter for today's webinar on remote employees in New York. We will get started in just a couple of minutes after everyone has had a chance to get logged in. We're scheduled to get started in about a minute. I'm going to just wait a little bit longer here to let everyone get signed in to today's webinar. If you can hear me and see the slide presentation on remote employees in New York, then you should be all set. Again, just make sure you familiarize yourself with the chat window so you can ask questions as you may have them during the presentation. Okay, I'll just go ahead and start with some of the preliminaries as people are still getting logged in. Before we get into the substantive material, I just want to say that I am Scott Horton with Horton Law PLLC based in Orchard Park, New York, outside of Buffalo. Today's presentation is Remote Employees in New York, Employment Law Traps for the Unwary Employer. Again, if you are hearing me and you have the presentation slide in front of you, then the only other thing you need to worry about is the chat window where you'll be able to enter your questions. Please do that as you have them. I may hold off on answering until the end of the presentation, but I don't want you to forget your important questions. The presentation will last about an hour and I will stay on to answer questions as long as there are questions still coming in. Of course, important question, but what about the slides? I will have the slides available for you at the end of the presentation, so you can download them at that point in time. Also, if you are registered, then you will receive tomorrow a copy of the slides by email. The only other caveat as we get going, of course, is if you do ask questions, keep in mind that this is not a confidential setting, so don't say anything that would require me to try to respond to a situation that needs to be kept private. If we need to have a privileged attorney client communication, we need to do that in a different forum. With that, I think we've had most of the people that are trying to get logged in right now get through. We may have a couple others join us. So I will go ahead into the presentation. You will see this slide again at the end of the presentation. I'm not going to answer these questions right now, but I just wanted to start out with some ideas that I consider big picture considerations on this topic. I anticipate, and we'll get to it in just a second, that we have many people here who either are based in New York but have remote employees, or who are based outside of New York but have employees who live and work remotely within the state. So we're going to address some New York specific laws and how they apply in both of those situations. But keep in mind, and we will come back to these questions, do remote employees subject employers to new regulatory jurisdictions? I think the implied answer to that is yes, but what does that mean? And how far does it extend? Another important question is, when is a remote employee working? This means, are they engaged in work for the purposes of compensation and other legal restrictions and requirements? You'll see that topic come up throughout the presentation. Who is responsible for workplace safety when the workplace is the employee's home or some other location that they have chosen without their employer's specific approval or oversight, for example? And then a really big question at the end of the day that I think we're going to eventually see answered or asked more often is whether working from home is a privilege or a right. This will come up in a couple of different ways, but with the considerable expansion of remote working arising out of the COVID pandemic, there is now a trend towards returning to the workplace, and there may be some resistance to that. And there's the possibility that there will be future developments heading one way or the other in favor or against remote work. So that question I leave you with as we go forward is one that I think will have more implications in the future than maybe it even does right now. Before we do get into the various legal requirements and how they apply to remote work, I just want to start with a question where you can all click in to answer, just to get an idea of who is listening to this webinar. Does your organization have any physical locations in New York? If yes, then click yes. If not, then the question is, do you currently then have remote employees in New York, or are you looking to bring remote employees who happen to live in New York into your organization? So it looks like pretty much everyone, or literally everyone so far, actually has employees in New York, and they're based in New York in some way, shape, or form. I know we have some folks on here who have locations in multiple states and multiple jurisdictions. It looks like everyone, at least who is responding, is letting us know that they are physically present in some way in New York beyond just having remote employees. But again, a lot of these topics will apply if that is your situation, as well as the situation where you are, say, based in a different state and happen to have an employee that you currently employ or are looking to employ who lives and would therefore work remotely in New York. Okay, so right off the bat, I'm going to get into a New York City specific law, and there are going to be a few references to New York City laws in this presentation. When I generally am referring to remote employees in New York in the title of this presentation, I am referring to New York State. But with remote workers in particular, even if you are based in New York State but outside of New York City, um, you may then have remote employees working and presumably living in New York City and therefore have to be somewhat familiar with the New York City regulatory issues regarding employment law that in some ways vary from what is required outside of New York City throughout the rest of New York State. So there are jurisdictional issues in that sense, even within the state boundaries. And again, if you were outside of New York and hiring someone who lives and will work remotely in New York, it will therefore be important whether that person lives in New York City and works there or lives somewhere else within the state and works there. So this New York City pay transparency in job advertisements law was put into effect earlier this year, although the provisions won't actually apply until November 1st. We're now just barely a month away from November 1st. So it's very timely to make sure everyone is aware of this. The law applies to employers with 4 or more employees, but only one of them has to work in New York City. This means that if you currently have no employees in New York City and are posting for jobs that could be performed in New York City, you're probably not subject to these requirements yet. But once you do have an employee working in New York City, presumably even if it's someone working there remotely, then you would be subject to these requirements for additional job postings. What are the requirements? Well, first of all, they apply to any jobs that could be performed in New York City. So if you are in Albany, for example, and hiring for on site positions in and around your facility in Albany, then you're not going to be subject to this requirement for your job postings. However, if you're in Albany and hiring for remote employees that presumably could work anywhere, or let's say at least anywhere within the state of New York, if you already have at least one employee in New York City, then your job posting would be covered because the work could be performed in New York City and you have an employee in New York City, of course, assuming you otherwise have 4 employees. It doesn't require that the job be advertised per se, although advertisement is really referenced in the name of the local law. We'll get to that in just a second. And there is an exception for temporary help firms seeking workers to join their pool of temporary workers, just in case you're in that situation. But the nuance there is the exception doesn't apply to temporary positions unless you're a staffing firm looking for people who are then going to apply or be placed in other workplaces. Likewise, if you are a temporary staffing firm and you're hiring direct hires to work on behalf of the staffing firm rather than be placed somewhere else, the exception doesn't apply to you either. So the job posting coverage includes anything from a formal job advertisement online or in a newspaper, for example, to something like a bulletin board, even if that's an internal bulletin board posting. So this does apply both to outside postings and internal postings. What is the obligation? The obligation is if you have such a posting in some way, shape, or form, and the position could be performed within New York City, regardless of where you're based and advertising the job, you must include in the job posting the minimum and maximum salary or hourly range for the position, where the range could extend from the lowest to highest salary or wage you believe in good faith at the time of the posting that the organization would pay for the job. You don't have to post overtime rates or other forms of compensation or benefits under the New York City law. You just need to provide a base salary or wage range. At this point, we don't have any further guidance really on what a good faith range might be. Presumably, there will be some challenges to that in particular circumstances. Likely, if you said we will pay at least minimum wage and as much as $100 an hour, that would be considered over broad in most cases. But anyway, the basic requirement is a range of the salary or hourly wage for the position. Again, this is a New York City law, but there has been proposed legislation at the state level. So a secondary consideration here is that while this currently applies for positions that could be performed within New York City, it could be in the future a similar requirement that this be done for any job that could be performed within New York State. And in fact, the legislation that was being processed at the New York State legislative level last term earlier this year would have gone beyond this and required, in fact, a written job description in the posting and additional information about the forms of compensation available for the position. So remains to be seen on that, but right now the New York City law does take effect November 1st. Somewhat related to the New York City wage posting requirement is a New York State law that recently went into place that prohibits employers from inquiring about applicants' wage or salary history. This all falls under the topic of pay transparency, which is of increasing prominence, not just in New York State, but elsewhere in the country. The concept here being that if you were to ask employees about what they earned in the past, that is likely to result in some sort of implicit form of discrimination where certain groups historically have made less than others. So asking what someone made in the past and using that information and how much you're going to offer to pay them at the job they're now seeking could therefore perpetuate wage discrimination. So if for some reason you get or have the applicant's prior wage or salary history, you can't use that information in deciding whether to hire them or determining their wages. This includes, for example, internal promotions, where presumably you may know what the person's current salary is because they're already working for you, but you can't refuse to hire them because now they would have to make more or whatever. You could still have an appropriate salary for whatever the position is, but you can't use their current salary in determining that rate. The exception here is for the situation where an employee discloses their salary to negotiate higher compensation. Presumably at this point, there's already been a job offer and a salary has been proposed, and the employee comes back and says, well, I made this much in my last job, or I'm making this much now, so I need more money to change to working for you. In that situation, it's okay for the employer to say, well, now I want to offer you more based on your previous salary, for example. I guess the way the law is written, it wouldn't stop the employer from saying, well, now we're going to pay you less. But I think that's less likely to be a reality anyway. But again, this is a New York State requirement at this point. So again, whether you're hiring someone to work on site or remotely, this would apply throughout New York State, but just particularly keeping it in mind for employers who are outside of New York and are now hiring someone who lives in New York and would work remotely, you would now be likely subject to this requirement as well. And that may vary from any law in the state in which you are located and may be more familiar with the hiring requirements. All right, moving along the spectrum now, assuming you have hired someone to work in New York State. For those of you who have existing employees in New York State and are established, this won't come as any surprise, but specifically considering folks who may be hiring a remote worker in New York as their first New York employee, there are insurance coverages that are required that may vary from what is necessary in other states. Most, if not all, states have a workers' compensation plan, but you do need to make sure that your insurance covers employees within New York State. I'm not aware of any exclusions for remote employees, but theoretically, having remote employees could impact your workers' compensation premiums in some situations. We'll allude to that a little bit more and what the coverage of workers' compensation may or may not be for employees who are injured in their workplace if their workplace is their own home. But the main point here is you do have to have New York State workers' compensation for most New York State employees, even if they're working remotely. Unemployment, again, New York State has an unemployment system, and if you have an employee working remotely in New York, they have to be covered by unemployment, just like any other employee in New York State who is working on site at an employer's premises. Now, the two forms of insurance that are pretty peculiar to New York State. New York's not the only state that has these requirements, but it's a small subset of the states across the country, are a short-term disability insurance program and a subcomponent of that in the form of paid family leave. So we're not going to get into too much detail on the coverage of those. And if you're established New York employers, you are hopefully familiar with those programs, unless you're in the public sector. If you're a governmental entity, you don't necessarily have to provide disability or paid family leave. And there's an exception for certain employees within nonprofits in New York as well. But certainly, if you are hiring your first New York employee as a remote worker, these are all insurance programs that you should be looking to make sure you're providing, as well as registering for withholdings for New York State tax that you should, in most cases, be responsible for processing once you have an employee working in New York. And here's another New York State requirement that, in fact, arose out of a New York City law. So New York City enacted a paid sick leave program, and then not too long thereafter, New York State picked up a statewide sick leave requirement. Now, this actually has a remote work specific component to it that I'll get to in a moment. But just as a review for those of you familiar with New York paid sick leave, and as an introduction for anyone who is not, you do have to provide sick leave to employees working in New York State under this new law, up to 56 hours of paid leave per year. The amount of leave and whether it's paid or not is based on employer size, and we'll get to that in a moment. Employees accrue at least 1 hour per 30 hours of physical work within New York. So there is relatively clear guidance saying that anyone who is an employee working for their employer within the state of New York has to accrue leave at the rate of at least 1 hour of leave per 30 hours worked in New York. Now, this applies not only to employees working physically at an employer's work site in New York State, and not only to employees who live in New York State and work remotely, for example, but even if your employee is based outside of New York State and travels into New York, once they have worked within the state of New York for 30 hours, they've now accrued under New York law at least 1 hour of sick leave. How and whether that would be enforced in certain cases is an open question, but there is guidance that makes it clear that's the situation. So, especially if you have someone who regularly works outside, for example, of New York City and commutes into New York City only occasionally, you should be thoughtful as to whether they're accruing that time and whether that matters. Part of the question of whether it matters is this next point, that your New York sick leave requirement can be covered through other types of leave programs, principally including paid time off. So if you have a paid time off program, you can include your sick leave under the PTO policy, but then your PTO policy has to meet certain requirements for the paid sick leave program. So there are specific situations where individuals can use sick leave. You'd have to be able to use it in all of those situations under your PTO policy, and they have to accrue it at least as often as 1 hour per 30 hours physically worked, and they would have to get at least as much leave as you are required to give them annually under the New York paid sick leave law. The law does allow employers to front load the leave rather than accrue it. So if you have employees who get have to get under the law 40 hours of paid sick leave per year, you can give that all on the first day of the year. You can actually set your year. It doesn't have to be a calendar year. It doesn't have to be your fiscal year. It can be any consecutive 12-month period. But once you have your year, you could front load the leave, and the law only requires you to allow someone to use up to that much amount of sick leave per year. Nonetheless, the law also says that employees have to be able to carry over unused leave. So whether you accrue it or front load it, at the end of your year, if the employee has any sick leave available, which potentially includes any PTO, if the PTO was designed to cover the sick leave requirement, then you have to at least theoretically carry over the leave. I say theoretically because in a situation where you front loaded the leave and satisfied the annual allowance, if you're going to do that every year, then it practically doesn't seem to matter that they carry it over, because they still can be limited to using only the 40 or 56 hours within a year. So it doesn't really matter if they now have an accumulated balance of, say, 112 hours of sick leave because they didn't use any in the previous year. The argument is that at least you should be documenting that, because you have to provide employees with their current balance of sick leave upon request. But again, make sure your policy is at least clear that they can't use more than the amount that the law requires in a given year, unless you're okay with them using more, which is also fine. Just real quick, how much leave you have to allow. If you have under 5 employees, then you only have to give 40 hours per employee. That is unpaid unless the company or organization's net income is at least $1 million per year, at which point it would become paid leave, even if you have less than 5 employees. Once you have 5 employees up to 99 employees, it's 40 hours paid. And once you're above 100 employees, they can get up to 56 hours paid, assuming they would accrue enough based on their hours worked. Okay, so we're going to move through a lot of different New York law topics. Some of the slides I won't go through in as much detail, but they're here basically for your reference. This one on meal periods, the specifics are set forth. There are requirements basically of a 30-minute lunch break, but when that technically applies is listed in this slide. The Department of Labor generally allows meal periods of 30 minutes, even in situations where the law would require more on its face, except that if there's an indication of hardship to the employees where 30 minutes isn't enough and the law otherwise provides more, then the Department of Labor may say they're entitled to the longer meal period. Um, for the purposes of this slide, I didn't address meal periods in factories, which by default are longer because it's unlikely you're going to have remote employees who are working in a factory. At that point, they're probably no longer remote employees. But the point being, for remote employees in New York, they're still entitled to these meal periods. So just the fact that they're working from home doesn't mean they don't have the entitlement to be relieved from duty for at least 30 minutes. And technically, if they don't take that, then you're in violation of the meal period law. It's not the employee's option, it is the employer's responsibility to ensure that the meal period actually occurs, which I suspect is not happening in many physical workplaces, much less remote workplaces, but it is the New York law and it would be enforced if someone were to complain about it to the Department of Labor. Again, even in the situation where the employee were voluntarily skipping their lunch or working while they're eating, which of course is relatively common, probably including if you're working from home. Minimum wage, again, this is one of those situations where it could be a relevant consideration for remote employees, whether you're based in New York State or not, because there is a distinction within New York State. So the minimum wage under federal law is $7.25 per hour. A decent number of states at this point have a higher minimum wage. And most of you know you have to satisfy the applicable minimum wage in the jurisdiction or locality, whether that be the state or some cities have their own minimum wages, in addition to meeting any federal requirement. Right now, under New York state law, the minimum wage for most employees in New York City, Long Island, and Westchester County is $15 per hour. But outside of those areas in the New York City metropolitan, the minimum wage is $13.20 per hour. So if you were, for example, based in Rochester, but had an employee working for you remotely on Long Island, make sure you know that that employee's minimum wage is $15 per hour, not $13.20 per hour. The minimum wage for the rest of New York State is likely to increase at the end of this year. The Commissioner of Labor is supposed to announce any such increase in the minimum wage by October 1st. So that is coming up very soon. But the last I checked this morning, there has not been an announcement yet on any 2022 year-end minimum wage increase. But my best guess is there will be one. Whether it gets to $15 an hour to match the New York City minimum wage remains to be seen, but that is the sort of threshold that the state has been looking to achieve statewide. Along with the New York State minimum wage, the state overtime exemptions have a higher salary threshold than the federal law. Federal Fair Labor Standards Act requires for exemptions that employees be paid at least $684 per week. In New York City, Long Island, and Westchester, that number is $1,125. For the rest of New York State, it's currently $990, which again would increase if the minimum wage for the rest of New York State increases at the end of this year. It is particularly plausible that you would have exempt employees working in New York City or Long Island, for example, while being based other places in the state. If that's the case, again, make sure you're paying them the higher rate for the overtime exemption, assuming you want the exemption to apply. One other note is there is no salary requirement for the professional exemption under New York law. So if you have an employee working as an accountant somewhere, for example, they are likely not subject to these $990 or $1,125 salary requirements. They would, in the case of an accountant, still be subject to the $684 a week salary threshold under the FLSA. Lawyers, doctors, and teachers are professional employees. And while there's no New York salary requirement for professional employees generally, the FLSA has a specific carve out for doctors, lawyers, and teachers where there is no salary requirement for their exemptions as well. Once you know what you're paying for a position, New York law requires a written wage notice to inform employees of the basic compensation terms. If you are used to hiring on-site employees in New York State, hopefully you've been complying with this law that's been in place for over a decade now. This disclosure needs to be provided within 10 days of the date of hire and when changes are made to the information in the notice. There's a enforcement caveat there. The Department of Labor doesn't mind if you haven't given a new notice in the case where you're raising someone's rate of pay. Not that you couldn't give a new notice, but if you're just increasing their rate of pay, it's sufficient as long as their next pay stub reflects the increase in the pay rate. If you are reducing someone's pay, then you need to provide another wage notice. The wage notice has to be in the employee's primary language, or at least if that primary language is one of the number of languages for which New York State has prepared form wage notice documents. And there are several of those languages. Once you provide it to the employee, you need to get it signed by the employee and then retain a copy of the signed form. Again, the New York State Department of Labor has forms available for different circumstances. You're not obligated to use their forms. You can do it, for example, even through an offer letter, assuming the employee signs off on it. But you do have to include all of the information that the law requires, which is listed here. The rate of pay, any overtime rates that apply, any pay increments, for example, if you have shift premiums or special work or special compensation for working on the weekends or anything like that, or if there is a commission component, you need to identify those types of things. Minimum wage allowances. So if you have tipped employees, although that would at this point in New York State only apply in the hospitality industry, which actually has slightly different wage notice requirements, and you're relatively unlikely to have remote employees working in hospitality. And even if you do, they're unlikely to be receiving tips. So there are meal and lodging allowances in some situations, and those would need to be identified. You also need to include the official business name, and the law says any DBAs doing business as registrations that the company has, and the address and phone number of the employer's main office. So again, if you're using your offer letter to satisfy this requirement, you would need to make sure all of this information is in it and that the employee signs it, and then the company retains a signed copy. So make sure you do that for your remote employees, as well as provide any remote employees with the policies that are required now under New York law. Many companies are going to have an employee handbook or policy manual that addresses many topics beyond the few that are listed on this slide, but these are written policies that are currently required under New York law, with a couple exceptions that I have a little asterisk by on this slide, which I'll explain. New York requires a written sexual harassment policy. So whether you have one employee or 1,000 employees in New York State, you need to have a written sexual harassment policy and provide that to the employee, as well as conduct annual sexual harassment training for all employees. Remember, this includes your remote employees. Don't leave them out. Paid family leave, again, we talked about you have to have that coverage. The law does require that there be a written paid family leave policy, in essence, with certain minimum topics addressed. Electronic monitoring and vacation, I have an asterisk by. These are not absolutely required to be in writing, but if you want to do certain things, you have to put it in writing. I'll get back to the electronic monitoring in just a minute. For vacation, the key point here is you should have any vacation or PTO or leave benefit in writing if you're going to offer them, especially if you are going to put a provision in place, for example, that says that no vacation will carry over from year to year, or that there will be no cash out of PTO at the end of employment, for example, where I'm using vacation and PTO interchangeably. Any of these leave types of policies, if you don't want to have to pay them out, you don't want to carry them over, and you want to put any other restrictions on them, you're allowed to do so generally, but it has to be in writing. If it's not in writing and an employee complains, you will lose. The Airborne Infectious Disease Exposure Prevention Plan is a new requirement arising out of COVID under the New York HERO Act. Ironically, the Airborne Infectious Disease Exposure Prevention Plan isn't limited to COVID. It is really designed to be in place in case there is a future outbreak of some disease, but right after the new requirement to have such a plan went into effect last year, COVID was in fact then designated as such a disease that required employers to put the plan into action. That designation is now lifted, so you're not required to have this plan in effect. But if you have an employee in New York, you are expected to have an airborne infectious disease exposure prevention plan and give it to the employee. For remote employees in particular, I've had plenty of questions about, do we have to somehow address employees working from home in our airborne infectious disease exposure prevention plan? There's nothing in the guidelines for the plans that addresses that very specifically. I think the biggest issue is having a plan generally for your physical workplaces. But I guess if you don't have any physical workplaces in New York, you would have to consider how you're going to comply with the potential obligation to have the plan, notwithstanding the fact that all your workplaces are employees' homes or other locations, except that I point out that the law does make it clear that employers only have to include mechanisms to make safe their controlled premises. So it's clear that you don't have to have measures in place for employees' homes, but it's also clear that you're supposed to have the plan, even if you only have one employee in New York State. That requirement doesn't apply to government employers. So there are some distinctions in what I'm talking about for public and non-public employers. I don't mean publicly traded versus privately held. I mean, are you a governmental entity or not? And that is one, that Airborne Infectious Disease Plan, that only applies to private companies and not governmental entities. Quickly, I'm not going to read all of this, but if you want to engage in electronic monitoring, which I think many employers would in some way, shape, or form, especially for remote employees, you must now have this statement in writing provided to such employees. You can say other things, and many people already have electronic monitoring or communication system policies that say words to this effect. But there is a new law in New York statewide that says you must have this language. The language, I think, is a little awkward, referring to radio or electromagnetic, photoelectronic, or photo optical systems, but the law says you have to put this in your policy. So put this in your policy if, for example, you want to be able to access your employees' email or see their internet usage, which are types of things that employers generally want to reserve the right to do. And I think specifically would be interested in, for example, to determine productivity among employees who are working from home. This next area that we're going to move into is the New York human rights laws. Now, largely, this is going to be a topic of the most interest to non-New York based entities that are now going to employ people remotely within New York State. For those of you who are already familiar with these laws, the primary point again is going to be there are some distinctions between New York State and New York City laws in this area. In New York City, the state law applies, but the city law also applies. These laws, importantly, are broader than the federal laws like Title VII and the ADA. But the New York State law and the New York City law are relatively comparable. Of the two, however, the New York City law is generally broader than the state law. Both of these state and city laws have the possibility for administrative adjudication, meaning an employee who files a claim of discrimination with these organizations can ultimately reach a hearing on the merits and potentially receive some remedy from the administrative agency itself without having to go to court, which is different than the federal laws where they would have to get a right to sue letter, generally from the EEOC, and then file a case in court, which is typically harder for an individual to do than just going through an administrative adjudication. So if you are from a state that doesn't have these types of procedures and now have an employee working remotely within New York, recognize that that employee may have these rights that differ from the laws in your home state and differ from what the federal laws are that apply across the country. On the slide, I'm not going to read all these. New York State protected characteristics include things like familial status and marital status and gender identity or expression that are not specifically covered by any federal discrimination statute and may not be covered in various other states. There are also limitations on discrimination or refusing to hire, especially based on prior arrest and conviction records. There are situations where you could hire based on those things, but you have to engage in a further analysis before you make that decision. This is the list of New York City protected characteristics, which is again a little broader than even the New York State requirement that includes, for example, credit history and immigration status as specific categories. Some of the named categories somewhat overlap. Sexual and reproductive health decisions has a particular meaning, but it's listed under the New York City law. Does that mean you could discriminate based on those decisions under New York State law where it's not specifically enumerated? Um, I would caution against quickly doing that. There may be coverages based generally on sex discrimination protections and or pregnancy and disability related protections. But again, I'm just providing you what is listed in the statute so you understand there may be distinctions. The harassment standard under New York state law is now much broader than under the federal discrimination statutes and the statutes that may apply in various other states. There is no requirement that the harassment be severe or pervasive under New York law. There are very limited defenses compared to the federal statutes, and the affirmative defense that the human rights law now gives employers is that the harassing conduct does not rise above the level of what a reasonable victim of discrimination with the same protected characteristic or characteristics would consider petty slights or trivial inconveniences. So if you're in New York, this applies generally, but if you are outside of New York and now have employees working remotely within New York, keep in mind remote employees are also protected against harassment and discrimination. Even though they might not be on site to experience harassment, they can nonetheless be harassed electronically or through other such means, and the standard under New York law is very low. The New York City human rights law standard also uses this petty slight, trivial inconvenience language, but this is an actual quote from the state law. Disability accommodation issues. Again, disability is more broadly defined under New York law than it is under the Americans with Disabilities Act. There's no requirement that a condition substantially limits a major life activity to qualify for protection under the state law. Again, New York City and New York State have different definitions of disability. Of the two, it's probably fair to say that New York City's definition is broader, but both of them generally encompass basically any impairment that an individual might have of a physical or mental nature. So that is a huge distinction if you are from a state that doesn't have protections broader than the Americans with Disabilities Act. The Americans with Disabilities Act was amended a while ago now to expand its coverage, but that expansion still does not go as far as New York State's coverage. The key point being, obviously, you can't discriminate based on disability in New York, and more people will be protected, but you also have to provide accommodations to individuals with disabilities, and that can include accommodating individuals who work remotely. The pre-existing question was whether remote work itself was a reasonable accommodation. Often employers were able to successfully argue, at least pre-COVID, that allowing somebody to work from home isn't reasonable or poses an undue hardship. And I think the ability to make that argument is reduced in the post-COVID world. So we don't know exactly what all the long-term ramifications are going to be. This goes back to that question I asked earlier about whether remote work is a right or a privilege, but it is likely that an employer who says we can't let you work remotely as an accommodation for your disability will be confronted with evidence of a large number of individuals who they did allow to work remotely independent of any disability during the COVID pandemic, and whether employers can sufficiently distinguish that situation remains to be seen. The other point, of course, is if you do have an employee working remotely, you still have the accommodation obligation. So you may need to help the employee set up even their home work location to be able to work with some disability that they may have. Again, it's a case by case basis to determine what is reasonable or an undue hardship. Whether a court or administrative agency would say that you have to build a ramp or elevator in an employee's home to enable them to work if they're in a wheelchair, for example, is probably a different question from whether you need to provide an ergonomic keyboard for an employee to use at home because they suffer from carpal tunnel syndrome. But again, these are all case by case questions that you can't just brush off on the theory that, well, they're at home, so we're not responsible. Beyond the employment discrimination statutes, New York has a law that protects off-duty conduct pretty broadly, and potentially more broadly than virtually any other state, and there's no comparable federal law. So again, this would apply to remote employees working in New York, but it raises some potential unique questions for remote employees. So generally speaking, you can't discriminate against or harass employees for their political activities, their use of lawful consumable products, their recreational activities, or union activity. Where the most interesting of these for relevant purposes is probably use of consumable products. So historically, you couldn't discriminate against, meaning fire or refuse to hire employees based on their out of work alcohol use or smoking. Now, as of last year, this now includes employee marijuana or cannabis use in New York, where recreational marijuana use is now legal. So especially if you're from a different state and you have an employee working in New York State, be aware that you can't drug test that employee for marijuana anymore unless somehow you can show you have a federal obligation that requires you to do so, which is probably unlikely for most types of remote employees unless they're a truck driver. But this also raises questions of what about employees who might be at home drinking or smoking, whether it be tobacco or marijuana, for example, while they are working for you. Real quick, just for your reference, this is what's now legal regarding cannabis and marijuana, possessing, using, all these sorts of things. But there are exceptions. So again, I mentioned if it's required by state or federal law, if you have truck drivers, federal law generally may require you to test for marijuana, among other drugs. But you also don't have to allow employees to be impaired by the use of these substances, such as marijuana. Whether you can prove whether somebody is currently impaired while working remotely is a tough question, but you can make it clear that they can't work and use cannabis or alcohol or any other legal substance that's not medically required during work time. Whether it's necessary to do that is one question, but assuming you don't allow employees in your physical offices or factories to smoke or drink while working, it might be problematic for you to allow employees who are working remotely to do so, again, while they are working. The last point is basically the same, but this is another specific carve out. All right, I think we are just about at the end of our hour, and here we are back to our big picture considerations slide. I have one more slide after this, and then we'll get to questions. I know there are a number of questions in, and I'll get to those. And if you have other questions, please go ahead and start typing them in. So again, do remote employees subject employers to new regulatory jurisdictions? Obviously, we're focusing on employment law here. It's not the only subject of law of interest. If you have employees working in New York State, you should at least presume that they're going to be protected by New York State employment laws. The human rights law used to be limited to employers with at least 4 employees, meaning 4 employees in New York State. That has dropped down to 1 employee. So again, you're subject, once you have an employee in New York State, you're subject to the minimum wage requirements and other requirements as long as you have an employee working in New York. There are tax issues. You should generally be submitting New York State taxes for employees working in New York, but there are some reciprocal agreements between states such that I believe an employee who lives in New Jersey and works in New York is taxed in New Jersey. So that's something else to keep in mind regarding remote employees. Although, if they live in New Jersey and they're a remote employee, they're probably still working in New Jersey, in which case you're worried about the New Jersey tax anyway. But there are some tax issues. Bottom line is check with your payroll company or accountant to make sure you get those right. The other jurisdictional issue is once you have an employee working in a state, you may now be subjecting your organization to potential legal exposure in that state. That could mean different things. If they're selling something for which sales tax needs to be collected, it's possible that you need to submit sales tax to New York State. If you're an LLC or a corporation, you may need, or for various reasons, want to register as a foreign entity in New York State. A little beyond the purposes of this presentation, but there are additional considerations like that. And you may also be opening your company up to being sued in New York State and subject to New York State courts and laws based on the performance of work by employees who are working in New York, even if your company is otherwise based somewhere else. When is a remote employee working? This is important for a number of reasons, primarily compensation, especially for employees who are not exempt. You need to know when they're working so that you know when you have to pay them, and you need to know when they work overtime so you pay them at the overtime rate. Is a remote employee working from the time they first turn on their computer in the morning to the time they turn it off at night, or are they only working when they're doing certain things? These are obviously case by case situations, and they're not only legal considerations. There's also the question of is this person working as much as they're supposed to be? Productivity and performance related issues. But there are other questions that arise out of this. For example, if someone gets injured in their home, do they have a workers' comp claim or another claim against the company? Obviously, not every injury that occurs at their home is going to lead to employer liability just because they work from home. But if, for example, they were to develop carpal tunnel while working at home on a computer, they may have a workers' compensation claim. This goes into the next point: who's responsible for workplace safety? As I said, under the Airborne Infectious Disease Exposure Prevention Plan, it does specify that employers are not responsible to maintain safely for that purpose an employee's own home. It would have to be somehow an employer owned or leased type of premises. But, a couple considerations there. That doesn't mean you want your employees to get sick or injured regardless, because you want them to be safe and working. And there are situations where they might have claims if they are injured while working. There are cases that arise under workers' compensation law, for example, if someone trips in their kitchen getting a drink while they're on work time, whether that entitles them to workers' compensation. And for those reasons, there are questions of whether you want to be inspecting your employees' home workplaces, which usually are desks, for example, and their computer equipment, but hypothetically could involve other settings. Of course, the other problem is you can't easily control whether employees actually sitting at their desk in the ergonomically friendly chair or slumped over on their bed. And if they do that and develop back problems, whether the organization is responsible for the lost wages or medical bills of the employee resulting from that condition. Finally, is working from home a privilege or a right? We'll reference this with regard to accommodations. Do employees have the right to the accommodation of being allowed to work from home? If so, temporarily, indefinitely, permanently? Um, and the other big picture question here is, if you hire someone, for example, and say, we're looking for someone, yes, you can work remotely, and they start working, and then you go back to them and say, we've changed our mind. We now want everybody in the office. What happens if the employee says, no, I'm not interested in coming into the office. I took this job because I wanted to work from home, and this doesn't work for me. Hopefully, in most cases, employers have discretion to make those types of changes, but depending on what promises or statements are made to employees and whether they rely on that in certain ways, it is possible that they could make some sort of claim saying that they've been, um, improperly denied of work under the circumstances. Almost done here. Just to tie it all up, remote work policies. Again, there's no specific requirement that you have a remote work policy. Ultimately, to the extent you're going to have something in writing about remote work specifically, I think it's more about business expectations than legal compliance. But of course, the legal responsibilities should be addressed. We talked about the electronic monitoring. Most companies are trying to do something to ensure they can figure out whether someone is actually working or not, whether you can actually install a camera in your employee's home office to physically look at them throughout the day. Is a different question. If you really want to do that, there's some considerations, but more often it's looking at their computer usage in some way, shape, or form. So do have that employee monitoring policy in place if you're going to do anything like that. You're also, of course, trying to prepare against liability. You may want to, as clearly as possible, specify when someone is working and when they're not. This also goes into the timekeeping issues. Presumably, you either have a mechanism to track time worked or the employee has to self-report it in some way, shape, or form. And ultimately, however, non-exempt employees have to be paid for the time worked, whether they were supposed to be working or not. So you need to make sure you are monitoring that to the extent possible and preventing abuse, both to avoid underpayment and overpayments. So with all of that said, again, there's no one size fits all remote work policy, but you want to figure out how you're going to ensure both that your legal responsibilities are being met, and that might be just through your other policies and making sure you give them to employees who are working remotely and remind them how they apply to them, or specifically spelling it out for remote employees, as well as working out how you're going to ensure they're being productive and performing their job satisfactorily as if they were on site. And you may be able to put guidelines in place as well, so you have something to refer back to if you believe the employee is not living up to the expectations. For any further updates, our first method of getting them out there is posting them on LinkedIn. So please sign up to follow Horton Law on LinkedIn, and you will get those updates as we have them. If you are signed up for our email newsletter, then you will get a monthly newsletter. We try not to bother you too much, though, and sometimes you want information that we have available more quickly, and that can be done through LinkedIn. The question and answer is upon us, and I will start answering those questions. But in the meantime, since we're already a few minutes over, let me put up the link to the slides. I have a question on the workers' comp, which I was just kind of discussing. When an employee is hired in New York but traveling within the United States and gets injured, what state's workers' comp law applies? It's not necessarily a one size fits all answer. There could be jurisdictional distinctions in different workers' compensation laws. But the key point is if you have a New York based employee, you should make sure they're covered under a New York workers' compensation policy, which is likely to cover that type of travel. As far as which law ultimately gets applied, it's less likely to be a critical concern at that point. It could vary, but the coverage, the insurance coverage should protect you. The bigger problem that we see is employer is based in a state other than New York and then hires a remote employee working in New York, and they don't add some sort of specific New York State workers' compensation coverage, assuming that their existing workers' comp policy will cover employees working in other states. That may not be the case. So whenever you hire employees in a new state, it doesn't have to be New York, you would want to make sure you have the insurance coverages necessary in those states. And some policies will cover employees across multiple states, but in some cases you may need to add a new policy specific to the state. Question, what if you have a remote employee that works for a New York company in a different state? Where do they pay unemployment, workers' comp, those types of things? It could vary depending on the state, but if you are based in New York State and you have an employee in California, for example, working remotely in California, you need to make sure that you are covering them in California. So you would be making deductions from their pay to California, any applicable taxes and insurance requirements in that state. If you have an employee who lives in Pennsylvania and works in New York, where they come across the border every day to work at a physical location in New York, then you're probably covered just by the New York insurances and making tax deductions within Pennsylvania. Again, I know New Jersey at least has a specific reciprocal agreement with New York, such that in that scenario, when they're coming across and working in New York from New Jersey, you're still submitting taxes to New Jersey. So some of those become very state specific questions. But yes, whether you're based in New York or elsewhere, once you have employees working in multiple states, you should make sure you're complying with everything in each state. If you have employees who travel for meetings to New York a couple of times a month, if they're in New York State more than 30 hours, are they eligible for New York sick pay? What if their home state offers paid sick leave? Yes, the law says if they're in New York for 30 hours at that point in time, they become eligible for at least an hour of New York sick pay. How that's going to get really enforced, especially for an employee who has now earned 1 hour of sick leave under New York law, is a separate question. And again, you don't have to have a New York State specific sick leave policy per se, as long as that person has the time available to them for those purposes. So if you already have a paid sick leave, either because some other state requires it or just because your company offers it, then you may be able to point to that to satisfy the new New York State requirement. Um, Again, at least hypothetically, if that policy, whether under other states' law or your own prerogative, is more restrictive on the use of the leave in certain ways than New York State would require, then arguably you'd be in violation of the law. I mean, I can only say that it's probably unlikely that if somebody accrues 1 hour of New York sick pay, that it's going to result in some sort of claim. But technically, that is what the law says. Is there an end date for the New York State COVID sick pay? I believe there is an end date for the New York paid vaccination leave, but no, for just if you have COVID and now have to isolate or quarantine, um, or well, I'll get to the other or in a minute. That law still is in effect that says that employees are eligible for up to 2 weeks of pay for having COVID. The Department of Labor interpretation from early last year says that employees can potentially do that up to 3 times, assuming they test positive on the second and third time. No, there's no end date. Whether that would ever be repealed or modified, it remains to be seen. But unfortunately, when that went into effect, there was no limitation like there was with the similar federal law. The guidance from the CDC, which New York State recently adopted, I think pretty much eliminates any or any quarantine requirement for individuals who have just been exposed to someone with COVID. So for the most part, your eligibility for COVID sick pay is now likely to depend on whether you test positive or not. But once you test positive, if you haven't already used it 3 times, then you are eligible for the sick pay. Does the 56-hour sick leave requirement apply to railroad employees? There is a federal statute covering railroad employees. I don't know whether it preempts the state law for that requirement, but there's nothing in the state law that would specifically carve out railroad employees, assuming it's a private company, which I'm assuming it would be if you're referring to railroad employees. But if, for example, you're talking about a transit authority in one of the cities where there are railed lines, then that law does not apply because they're public entities. If a company has all remote workplaces, then the New York HERO Act doesn't apply. Really broadly speaking, the answer is if you're in the private sector and you have employees in New York, I think you're covered by the New York HERO Act. The New York HERO Act actually has two parts. One is the Airborne Infectious Disease Exposure Prevention Plan requirement. The other allows for employees to form workplace safety committees. I'm forgetting now the threshold, 10 employees for the workplace safety committee component. I'd say that part certainly still applies even if they're fully remote. But as far as the Airborne Infectious Disease Exposure Prevention Plan, I don't think there's anything to give me any confidence to say you can ignore it entirely if you don't have a workplace owned or leased premise. I think you should still have a plan in place, but you may just be noting in the plan that we don't currently have any company owned premises, but you would still presumably be entitled or obligated to give training to employees, for example, whenever you have to implement the plan. So I would try my best to put a plan in place just to check the box, even if I didn't have a physical workplace, if I had employees working remotely. But what the liability is likely to be or the odds that somebody would challenge that, I can't guess. There's a question about COVID and paid sick leave. So, yeah, just to be clear, that COVID provision is separate from the paid sick leave. So, if you have COVID, you're entitled to potentially up to 3 leaves that don't count against your paid sick leave. There's still open questions. I think when the law was written, nobody anticipated that anybody would get COVID more than once. So the Department of Labor said it could happen up to 3 times. Presumably, that 3 times means ever and not 3 times per year. But the law doesn't specify one way or the other. But again, whatever it is, if that law applies, then it's separate from paid sick leave. Is there a violation when a position that has not been posted, but a candidate has been selected? I'm not exactly sure how the rest of the wording here, but so the New York City pay rate disclosure requirement only applies when there's a job posting. If you just have an employee that you want to hire and you just contact, or if you have an individual that you want to hire for a position and you just contact them and you haven't actually posted anywhere, you're not obligated to disclose to them upfront how much you're going to pay for the position. So that's whether you're talking about someone who would be a new hire to your company or a promotion. So if John is a manager and you're going to promote him to a director and you go to him and say, hey, John, we want to consider you along with a couple of other people internally to move up to a director position, you're not obligated to disclose the pay rate. But if you put something up on a bulletin board, intranet, or on the internet, or in a newspaper, for example, at that point, you would have to include in New York State starting November 1st, the reasonable range of wage or salary. There was another question about head count for sick leave. Are all full-time, part-time, and temporary employees counted, and what is the period of the head count? So yeah, it is individual employees. They're not a like FTE, full-time equivalent calculation. It is how many people work there. The time period I can find out in just a second. I don't remember, but I will look it up. Um, yeah, the head count is relatively clear. The complication becomes if you're looking at whether it's employees in New York State or out of New York State. There is not very clear guidance on that. Arguably, it is just employees within New York State, but there's also an argument to be had the other way. What is I'm literally refreshing my recollection on the number of employees. It is the calendar year. It is a calendar year reference, so total number of employees in a calendar year. So if you in 2021 have had 100 employees over the course of the year, then in 2022 you will be obligated to provide 56 hours. There's another issue. The question was asked about employee work somewhere else. Where do you pay their workers' comp? Again, the default is going to be the site, the state in which they work, but there are potential caveats on that. The other point that comes up sometimes and has been litigated is if you have an employee in another state, can they file a claim under the New York State or New York City discrimination laws because the company is based there? Or let's say hypothetically, you have one employee in New York City and another employee working remotely in Texas. If the New York City employee remotely, through whatever means, harasses the employee in Texas, the employee in Texas tries to file a harassment complaint in New York City or New York State. There's a recent case that suggests that the does not have jurisdiction in New York because the impact of the harassment occurred in Texas. So that is another issue and a recent determination. That's not to say there couldn't be different circumstances if you change the facts slightly, if that employee in Texas also had to occasionally come to New York City and say perhaps meet in person with the person in New York City who allegedly harassed them, then perhaps that would expand the coverage of the New York and or New York City laws to that situation. Yeah, if the number of employees fluctuates from month to month, you're still looking at total employ for sick leave. You're still looking at the total number of employees over the course of the calendar year. I mean, the law is designed to provide as much coverage as possible. So you could never have more than 4 employees at a time. But if you have enough different employees over the course of the year that you've employed 20 or 100 individuals over the course of the year, then you are now subject to the greater 56-hour requirement. Or likewise, going from unpaid to paid when you go from 4 employees to 5 over the calendar year. I don't think I see any more unanswered questions. If you have any other questions, feel free to throw them in. I will stay on for another moment or two to answer them. If you have questions afterwards that you want to follow up with me on, here's my contact information. But I thank everyone for listening in on today's webinar. Again, if you don't want to download the slides now, if you're registered, you should get an email tomorrow with a link to the slides. Not seeing any more questions, so I am going to go ahead and wrap up the webinar. We do these almost monthly, so stay tuned and hopefully you will join us again.